There are millions of acres of opportunity out there. They belong to you. Every day, decisions are being made that affect your land, your water, your wildlife. You should know about them. This is your mountain. Hey everybody, welcome again to another episode of the Your Mountain podcast. I'm surrounded by two extraordinary gentlemen today. I don't know where Nephi and Mike are. I'm just kidding. Yeah, that was a pretty good joke, wasn't it?
You were about to get complimented, but you just wasted that opportunity.
I'm kidding. I'm giving you a good compliment. I am surrounded by extraordinary gentlemen here. Nephi.
Are we in a league of our own?
A league of extraordinary gentlemen here. Nephi, how are you doing?
I'm good. I feel like a stereotypical middle-aged man on a podcast.
All right, well.
That'd be true.
All right.
Is that everybody that has a podcast is middle-aged?
Yeah, pretty much.
No, I thought most of them were like millennials.
We'd like to believe that.
I think we're on the old end.
All right.
Yeah.
That's why you're listening to this podcast, because we're so something.
And I'm not middle-aged.
You know what I'm happy to see right now? Mike has a veritable handful of 45 caliber bullets just sprinkled like salt, like garnish across his desk.
I'm surprised he has anything left. We shot so much this weekend.
Yes, we contributed to conservation.
We, if we were to add up our contributions to conservation over the weekend,
every time a piece of that brass hits the ground, you go one nickel.
Unless it's 22s, and it's like one fraction of a penny.
not lately, it's not.
But we I don't know. What do you think? We probably put through collectively, it had to be 1,000 rounds.
That's probably right.
This weekend.
That seems right. Feels right.
It feels about right. Yeah.
My shoulder's sore.
Yeah.
That feels right.
My favorite part was, Mike's getting some new cutlery. Is that the right term?
Pots and pans
for his camp kitchen. And so instead of clay pigeons, we shot Mike's old pots and pans.
They hold up really well.
Well, good for you guys. And hopefully all your children who are listening to this don't do this at home. We would not advocate this from a safety standpoint, but hey, glad you guys enjoyed it.
We were perfectly safe.
Yeah, what could go wrong with you guys up there? Nothing.
Nothing did.
Man.
It was amazing. We caught lots of fish. We shot lots
I've seen
of guns.
some pictures. I'm not saying that anything could possibly have gone wrong. I'm just glad nothing did.
Nothing
I'm
went
not
wrong.
Insinuating anything.
Yeah, well, as far as we know.
As far as we know, nothing went wrong.
Okay.
So it was a good time. But now we're back.
Yep.
And
camp is over.
Instead of goofing off at man camp, we're going to get super wonky. There's all kinds of stuff going on in the world right now, in the natural resource world right now. You've got, for example, the wolf delisting comment period. There's a nationwide proposal to delist wolves. A proposal to delist wolves nationwide. And there's a comment period on that. Nephi, you were at one of those comment at the
I was at the hearing in Minnesota.
In Minnesota,
that was great.
Right? So that comment period ends in a couple of weeks. We're not going to talk about that today.
That's okay.
LWCF. There's a big push to permanently fund the
tell
Land
you
and
one
Water
thing.
Conservation Fund. What do you have to tell me?
I got to tell you, I've never seen so many people show up with stuffed wolves under their arms to give testimony. That's it. Go ahead.
Okay. So you haven't gone to these kinds of things before, because I've seen...
It's like stuffed animals everywhere. I'm like, really? This is how we're going to...
I was at a grizzly bear delisting, or is a hunting season meeting, right?
Mm-hmm.
And I watched somebody bring in a ceramic grizzly bear and then pictures of every named grizzly bear. To oppose any kind of hunting.
It was something else, I'll tell you.
Yeah, I'm glad you got to go or had to go or whatever it was. Anyway, so LWCF, there's a big push for permanent funding for the Land and Water Conservation Fund.
Which we've talked about on this show.
It's been permanently reauthorized now, but now there's a push to fund that permanently. We're not going to talk about that. There are new regulations that are going to come out in the next few weeks about the Endangered Species Act. The federal government put them out for comment late last year, and they're going to finalize those. So they'll be published here in the next couple of weeks.
Good for you guys.
We're not going to talk about that.
Well done.
There's now a huge proposal.
At least not today for all these things.
No, there's a huge proposal out there to streamline the way NEPA is applied in the National Forest. It's going to go out for public comment here shortly.
We're not going to talk about that.
We're not going to talk about that. Mike, what are we going to talk about today?
Well, okay. So you guys mentioned a lot of cool things that are happening, and they're going along on a normal track, right?
And we will talk about them at some point.
Yeah.
I should clarify, but we're not going to talk about those today.
Every once in a while, something happens that you're not even paying attention to. And it has a possibility for creating a tectonic shift in the way things roll out in the future as it relates to natural resources. We might have had that happen last week in the United States Supreme Court.
I like how you said might.
That's right.
A lot of conviction behind that statement.
Well,
spoken like a lawyer.
No, I can give you all the sides on it, and even some of the justices are wondering whether this means a lot. But
And it's not a case we've already talked about.
yeah, it's not. It actually had to do nothing
With natural resources.
with natural resources.
Neither one of them. You're talking about two today,
Yeah,
right?
there's two. Really, one's more important than the other, but one sort of leads to the other,
Yeah.
I guess is a fair way to say it. But so normally, we pay attention to the big cases up in front of the Supreme Court that are natural resource based. What's going to go on with your public lands, your water, your wildlife, and things like that. But every once in a while, something else happens that you go, wait a minute, what's this going to mean? And the case that more likely than not is really going to have a sort of quiet shift in the next 10 years is going to be the census case. Now, case about the United States Census.
Let's say now the census case. Are you talking about the case last week where the Trump administration had proposed adding a question
Yes.
to the census, a citizenship question?
Are you a
Correct.
citizen of the United
Are you
States
a
of
citizen of the
America?
United States?
Yeah, so it's the case of Department of Commerce versus New York.
And I'm
Right.
just going to throw this out from the outside because I was looking at this and as I walked in here, I was like, it just seems like maybe like if you're trying to count a number of people that should therefore determine how you get represented in Congress, being a citizen might be an important part of that.
Yeah.
Right. So you're talking about, I just want to be 100% clear, and then I'm going to, you explain the case. But we are talking about the case where several months ago, maybe it was more than several months ago, it was maybe a year ago, President Trump said, or the Trump administration proposed adding a citizenship question to the census, which hasn't been done before. Or maybe it has.
It has.
Maybe it has. Okay,
Yeah.
so I'm going to turn it over to you.
There we
go.
go.
Let's turn it over to the person that actually knows
So
this.
just give a little bit of history. So the most immediacy issue is that, yes, President Trump comes into office. Wilbur Ross is nominated to be the Secretary of Commerce. And within a week, he said, okay, let's see if we can add this citizenship question back on. I say back on because we've been doing a census every 10 years since 1790. And about 1820 is when folks started adding a question on, well, are you a citizen or not? In fact, Thomas Jefferson was the one that thought, hey, you know what, it might be nice to know how many people are naturalized citizens, how many are immigrants and things like that, so we can track our population and
So
see
that's
how
200
that's
years
going.
ago.
Yeah. So the question of citizenship has been on since 1820 in one form or another. Since then, up until 2010, and really since 1950 forward.
They took it off in 2010.
Yes. And since like 1950 forward, they kind of really changed the way they do the annual census, or the every 10-year census, I mean. And so they created short forms so that we all get a short form, but some people get a long form, and then sometimes at some point they took that citizenship question and put it on a different type of thing, a different questionnaire that goes out. But nevertheless, there's a long history of having a question on are you a citizen or not in the census.
Yes, it sounds to me
It'll
like
ask, I mean, there were times where we're like, how many radios do you have? Just randomized questions, including citizenship and other basics. And in fact, the United Nations says it's a good idea to ask that kind of question. Major first world countries ask that question in their own location. But there was a question in the United States about what's the motivation behind that.
Well, so
what's the motivation behind? I want
to go back to 2010 just really fast.
Yeah, I wanted to go there too. Go ahead.
So why was the citizenship question removed in the first place? Before we talk about why the reasons for putting it back in, why was it removed in the first place?
That's not in the case.
So I've heard something on the radio on a report about this.
On a podcast.
On a podcast about it. I mean, maybe we're talking about the same one. Are we? Is this where you were going to go?
No, I'm just joking because it's a podcast.
Because it was a podcast.
Yeah,
where
go
I heard
ahead.
it, right?
So it must be true.
Well, it's a reputable source.
Yes.
Maybe you listen to the same podcast. I don't know. But this is a very reputable one, right? I hope people take this information.
Go.
Okay. So the idea was that we want to get, the purpose of the census is to get the absolute most accurate count of the number of people we have in the country. Mm-hmm. And that if you put a citizenship question on it, because of the illegality of not being a citizen, potentially being here illegally, or other factors related to just folks not wanting to share their citizenship status, we may not get an accurate count of the number of people that are actually in the country.
Right. Well, that went into the debate around whether to add this, for sure. I know that. But the decision in 2010, why they removed it, I don't know. But internally within the agency, when they were wrestling with this question, when the Secretary of Commerce was looking at it, there were some folks who do statistics and these types of analyses, and they basically said, you are going to have about 5.8% of the population that are not going to respond because of concerns over these types of things. And it disproportionately affects minorities and Hispanics, and that's a problem. And when we talk about 5% or something, it seems minor, but anytime you are causing problems with the data that then results in how you're underreporting, yeah, but I mean, it's millions of people.
It's almost 20 million people.
Yeah, so, but it also has, that information is then used to figure out who gets however many representatives.
Yes, and here's what gets
in the
interesting.
Congress and all that. So
because you got two different types of problems, right? With the first one, we're saying, well, we might be underreporting, so we may have a community, Talis, Mexis, or what, or like let's invent some town in some state that's going to have, where it may have a higher proportion of certain individuals than another. Well, and if those folks don't respond to their census request, then we could be under, they may have federal agencies that need a certain amount of money to provide services there, that then they don't have the money to provide those services.
Oh, it's significant because you figure we're spending about $10 billion a day as the United States.
Is a B?
Billion. Yeah, don't worry, 4.5 billion of that we're borrowing, so
perfect.
It's okay.
Yeah. It's not real money.
Yeah, right. Yeah, no, of course those numbers are a little
old.
It's
Chinese money.
The fact of the matter is you're spending a lot of money, and that census question feeds into the process of figuring out where our populations are, how many representatives we get, and also sort of how we're going to dole out the money and provide services based upon what we know about the populations in the United States.
Exactly. So here's the problem. On the flip side of that coin, if we're using that same data set to then determine representation, which is based on, you get X number of people in Congress based on, and the expectation of that representation is those represent registered voters. Those represent people who vote. Well, now you've got you got a problem now.
Is representation based on registered voters?
No, not registered
voters. It's
voters.
based on population.
It's based on population. So normally Nephi's digging into the Second Amendment. That's really what he's worrying about. And he doesn't pay attention to
I'm actually not talking
Article
about that.
1, Section 2 of the United States Constitution,
which, by the way,
amended.
That is a
smallest constitution.
You just pulled out a pocket
well
constitution out of your lapel, and
That's
it's
right.
got more tabs than pages.
Yeah, it does.
And I normally, when somebody pulls out a pocket constitution, that's an immediate red flag to me that they don't know much about the Constitution.
Well,
but
yeah,
I make an exception for you.
Yeah, right. So, okay. Article 1, Section 2, Clause 3 of the United States Constitution describes basically the need to have every 10 years a census where they count folks. Now, that was amended by the 14th Amendment because we didn't always count people as whole people back in the days. But we've corrected that. And so it's an important thing. It's something we have to do, and there are a lot of consequences that flow from it. But really, that's not why I wanted to bring this case up for our listeners. Because what's important is that when the Secretary of Commerce made this decision, he did it, and it was analyzed under the Administrative Procedure Act, which is the procedure that every federal agency has to use to make a decision.
The APA.
The APA,
yeah.
right? So anytime you do a land management agency, just like if you want to create a land management plan, or you want to approve a logging project, or you want to do anything to get in and out of like the Endangered Species Act, this law is at play. And so anytime the United States Supreme Court interprets something under the Administrative Procedure Act, you have a chance that what they say will then bleed into every other area.
So what did they say here?
Well, it's fascinating because They walk through the.
This is where it ties to
normal-
our natural resources work for everybody who's trying to follow the wonkiness.
Yeah, right. So the court and the majority outlined essentially all the normal standards that we expect under the law, where they say, look, we're not experts. We're just the judiciary. You guys are the experts. As long as you explain your reasons and you follow certain procedures, we're going to let you go. And they basically said all that. And they even went so far as to say it doesn't matter what your subjective motivations are. So the Secretary of Commerce could have walked in the door wanting to undercount minorities and potential immigrant populations. That could have been there. But that doesn't necessarily matter. It could have political motivations to do that, so we can get more Republicans in or whatever. That doesn't matter. You get a presumption of you're doing it right. However, if there's some inkling of that there was some bad faith gone in there, and the reason you gave for why you chose the decision you did, if it's based upon pretext, then they can throw it out.
You got to explain that.
So this case came down to the fact where the Supreme Court said, yeah, you did your record right. You walked through and you looked at all the problems that were identified. You did your math. You considered the negative consequences of what you're about to do. You considered the positive consequences about what you're going to do. And you made a decision that in your discretion. However, we have some reason to believe that maybe the reason you gave for it wasn't really the right reason, or wasn't the reason.
So basically, you could have come in and said, reason A is the reason I'm doing this, even if it was unjust. But if you come in and you say, reason B is the reason I was doing this, but it was really reason A, then the court's going to slap
Well, let's
you.
explain the actual reason they gave and what was the reason the court gave, or not the court, what was the reason the administration gave that the court had question about?
So the Secretary of Commerce was very succinct in his statement. It was like a letter. So this was informal, sort of. It wasn't like a notice and comment procedure. But basically he just said, I really want to go down this route because it's important to have this type of information, and it is important for the Department of Justice to be able to know how many aliens we have in here, to try to figure out whether there's any Voting Rights Act violations going on. So it was under the guise of an enforcement thing that would benefit those communities. But the consequence being that they're less likely to respond to the questionnaire. So it was a very simple sort of, Department of Justice asked me for this information, and so I'm going to go ahead and give it. Now, what happened was the district court judge granted the parties' request to get a little bit more information and dig in and try to find some extra emails and things. And what they discovered in that process was that, well, okay, maybe that wasn't exactly how it worked. Maybe the secretary went to the Department of Justice and said, would you please ask me to do this? And then the Department of Justice accommodated and said, sure, we'll ask you that. That will help. And so this was teed up as being a pretextual type of thing, and nobody was talking about the Voting Rights Act until the very end, once it was sort of a justification, right, at the very end. So the court said under the APA, when you do that, that could be a problem. So you can have any number of decisions, political or not, motivated or not, in which someone now can come in and argue that the decision was pretextual.
So somebody wanted a certain result beforehand, so they did this to get the result, and how they got there may not have been entirely genuine.
Which is still okay, unless you're dishonest about how you explain what you decided to do.
The integrity of the process.
Has that not always been the law? Is this charting new ground, or is this by the Supreme Court, or is this reinforcing what the law has always been?
This is the first time in which they've said, you did everything right. And in fact, you can tell us all your reasons, and you can have additional reasons you don't tell us about.
Just don't
However,
lie to us.
Basically, yeah.
But don't lie,
I call it the red herring rule. Just don't give us a red herring when you make this decision.
It's interesting.
So this doesn't seem landmark by any, like in my mind. I'm
Doesn't
sitting
seem
here
that
thinking,
challenging.
I'm thinking, Well, yeah, I want my elected officials to. Yeah, not nice. I'm trying to hit them, and I'm about to unplug everything for saying challenging. Right?
Yeah.
It doesn't seem. I mean, that's what I want from my decision makers, my elected officials, is to be honest with their decision making.
Yeah, no, I understand that, and that makes sense. It's just
it just never had to be articulated before.
well, no, the court of law is not necessarily about fairness. It's about justice, and you have to have certain ways.
But
in
justice
which,
is fair, typically.
typically, yeah. But the thing is that this is kind of a squishy standard, and that's not how the court normally operates.
So how, if you were to take this
I was
decision and think of a way that it could be applied in a natural resource context, like for our listeners that are out there saying, okay, I'm very interested in watching how, like I mentioned at the beginning, how LWCF plays out or how wolf delisting plays out.
Mm-hmm.
Let's take wolf delisting for an example, a nationwide wolf
perfect
delisting
example.
rule. Let's use that as an example.
Let's say
Let's apply this holding to a wolf delisting process, which has to go through the APA as well. They propose a rule to delist wolves nationwide, and that has to go through an entire notice and comment, the entire APA process, right? And they have to explain their decision. How does this holding apply to, or could it apply to something like wolf delisting?
Well, there's a lot of ways in which it could not. That's for sure. There's a lot of ways in which they can run through everything fine. But let's say the president tweets, we're going to delist these wolves because they eat some animal that we really like, some charismatic animal we like. And they go through and they do the analysis and they figure out, okay, well, the real reason we need to delist them is because there's a sufficient number in the population's fine. But we all know that they're really doing it because that's what the president said. And so someone could come in and challenge the decision for all its soundness and goodness, despite all of that, can challenge it and say, your decision was pretextual. You did it because
based on what that tweet said, not based on the real.
But I thought you had said it can be politically motivated. And so if the president says delist it, there's a political motivation. Where, in this instance, if the president says delisting, where is the sort of the lie, the
Right, yeah, well, you're asking me to come up with a hypothetical on the fly. However, I will point out that the Supreme Court, the majority opinion, did say it could be political and be all those things, and yet that's kind of why they called them out on it, was they made a political decision.
Right, but they did it without being transparent about it.
Right. So if you were to go into the dissenting opinion by Justice Thomas, then you would see how he kind of points out that, look, this is crazy. You are now imposing a whole new obligation on agency heads who are supposed to be allowed to make these decisions, come into office and impose their viewpoint on things, but you're creating a pathway to challenge things that are based upon those changes that are politically based.
So in effect, what this does is it opens a window for creative litigation.
It does.
Congratulations, Dave. You're going to be employable.
That's right.
So we can call this the Additional Employment Act
The
for
Lawyer Protection
lawyers.
Act.
Additional
The
Lawyer Employment
LPA.
Act. Yeah. Well, it certainly will be, and I think you'll see in the next 10 years a series of cases that involve this. Oh, it's just pretext. Now, it won't be the only claim in the case. That will be an additional one.
But it creates a new argument.
So, right, it creates a new argument, which is part of the Thomas's dissent. Says, like, I hope this is just an aberration. This was just a one ticket for one train today,
But it won't be.
Well, you never know, because if you were to look at Massachusetts versus EPA, where suddenly the Supreme Court tells the EPA they have to regulate carbon dioxide as a form of pollution, they had in there, well, states can bring these kinds of cases because they have special solicitude and all that stuff. But if you were a state trying to bring in a case under your special solicitude sort of attitude of, I'm a special person, I can do this on behalf of people. If you try to do that, no court's going to buy it. And so there are those kinds of cases that are results driven, and they address a problem and they don't create precedent, but we don't know with this.
Yeah, it seems a little squishier.
Yeah.
Right? It seems like what you've done, and I'm thinking about the traditional litigious groups in the environmental community as far as these types of natural resource, land management planning, challenges to grazing allotments, ESA listing, delisting decisions, that sort of thing, where a lot of these groups take a kitchen sink approach in litigation. You might have a 15 claim complaint in the lawsuit, and maybe one or two of them are legitimate. This just seems like something,
a new dish to throw in the sink.
Yeah,
so
a new dish in the sink.
Yeah,
That's good.
Justice Alito also wrote an opinion that is called a concurrence opinion, or at least concurring with the dissent. And he's dissenting, basically saying that if this case is taken as a model, then you've got about 1,000 district court judges who are going to be potentially receiving information about some controversial topic, and they might have been motivated. That agency might have been motivated by some unstated reason, and so that is teeing up a mechanism for the court to then question a cabinet official or some high-ranking person's thought process in order to pass judgment on whether it was pretextual or not. So even Justice Alito is calling it out, and he thinks, well, this is the kind of thing that we shouldn't even be getting into.
Yeah.
That's totally within the Secretary of Commerce's discretion.
Well, it seems like he's even hinting, maybe he's not, maybe I'm misinterpreting the way you're describing it. I mean, there's a lot more text there, and maybe he doesn't intimate anything there. But in some of these natural resource fields, one thing that you have a lot, and you have it in other fields too, but we work in this area, you see a lot of what we call forum shopping, where folks are looking for sympathetic judges. And what this seems to do is if you find, I'm thinking about it, again, we'll stick with the wolf. We'll stick with the wolf issue because it's very controversial, and there are people that have preconceived notions about wolves, whether they should be listed or not. And judges aren't immune from having those preconceived notions. And I'm not making a blanket description across board as far as accusing all judges of being judicial activists, but there are certainly judges out there that you can make a case that they legislate from the bench. And could this be used as a foothold for a judge like that to make a decision under this pretextual context? Because they want to see a certain outcome.
Potentially, it's another way they could do it.
It seems like it'd be a high bar.
I'd like the way you
to be honest, this seems to me like that would be a high bar to try and say this is the reason the guy made the decision versus this other reason. And I'm saying that just because in all these complex natural resources issues, there are multiple working hypotheses. There are multiple reasons for making and coming to each of these decisions. You mentioned wolves, so going back there are a lot of different reasons why to say that are right and legitimate for why wolves should be delisted. And so having one be more right than the other doesn't make the other one not right. It just means that there are a lot of different reasons. And so the fact that you can say, well, this guy thought that wolves should be delisted because of A, but I really think they more delisted him because of B, that doesn't mean that both A and B aren't correct.
Right.
It's very heavy.
But the purpose of a lot of this decision, the purpose of the processes behind the decision making is to make sure that you are doing it right. You're thinking about the stuff that's going on, and there's not some glaring thing you're ignoring to the detriment of other things, but also to create a record that demonstrates why and what you're doing, so the public knows, because government's supposed to operate in a fishbowl.
It's the transparency piece.
Right.
Yeah.
And so if there's some unstated reason that's sort of something hinky going on here, then that might tee up and open up an opportunity for someone to come in and litigate over a controversial matter.
Well, this wasn't quite wonky enough for me. So what else have you got?
Okay, so what's fascinating about Alito's dissent here in the census cases, he's taken the point of, look, this is totally discretionary. This is the form of the APA in which it's solely under the discretion of the decision maker, and it's a political question, which gets us to our gerrymandering case.
Oh,
the other case.
Now you've got me.
Which is the RUCO versus Common Cause. I think that's how you say RUCO. So this had to do with gerrymandering, in which the United States Supreme Court did say, look,
Really quickly explain what gerrymandering is.
Gerrymandering is a new thing, right?
Yeah.
This is new.
No,
No, it's been around forever.
Yeah.
We didn't just invent it.
He was tongue in cheek.
Yeah.
So
Wait,
okay.
you were being, oh my. I didn't pick up what you were laying down.
Yeah.
Dave, you need to be in tune.
So-
Mike and I are in tune.
Yeah, it took you too literally there.
So let me get to the punchline on how the similarities, and then I'll explain it. Is whereas Alito in the census case said, we have nothing to judge this by. We shouldn't be doing it. We shouldn't be going into this. In the gerrymandering case, Robert said, this is a political question and it's not something we can address. There's no standard for us to apply. So they just punted and said, that's up to the legislature to figure out. Don't come to the courts with your questions on these things.
Can we nuance that just a little bit?
Mm-hmm.
Help me out, because I didn't. You read it, I didn't. I thought it was related to state legislature gerrymandering.
It is.
And so the Supreme Court was saying that's a state issue.
No.
It's not. We're not going to weigh into it because it's a state issue.
No.
Okay, correct me then.
Okay, so under the Constitution, where they talk about apportionment, where they talk about how you're going to figure out where the boundaries are of your districts for your representatives, that is something that has been delegated down to the states to handle for themselves. But the United States Congress has the ability to pass laws and kind of check and make sure that nobody's doing something wrong. So it's not that it's purely a state function. It is both. It is a state legislature function and it is a federal legislature function. But under no instance is it a federal court function. There's nothing for them to apply or think about in a constitutional sense. And the point of this case is that there's no unconstitutional action going on here, and we won't know what to do, and we won't weigh in as a federal court until the legislature passes a law that constricts how this happens.
They just said, you're asking us to legislate from the bench. We're not gonna.
Right. It was an amazing sort of punt in an area that is rife with debate.
And this is, as I said,
so gerrymandering.
New, right?
No, this is not new. Okay, so gerrymandering.
been around as long as the census.
It actually has been around longer than the census because it was during the first congressional election. George Washington and his Federalists were all complaining because there was some gerrymandering going on in the Virginia districts.
I don't even know what to call it yet, though.
It didn't at that time.
Who's Jerry, by the way?
We're gonna get
let
to
me
that.
get to that.
Okay.
Let me get
Be
to that.
patient,
Okay?
Dave.
Oh, right. Well, I
Get
didn't know if
into
he
it.
was going to get there. I just want to know who Jerry is.
So basically, you had the Federalists. In basic, Patrick Henry was the one in Virginia that was redrawing the boundaries of the congressional districts in order to favor James Madison, who prevailed over James Monroe, which is fascinating because you got future president, vice president, you got a president, you got everybody kind of messing around here with how to redraw who gets
there
to
weren't
vote
a lot
where.
of people then.
No, there weren't. So
Everybody had to
gerrymandering-
take their turn at being president.
So gerrymandering comes around in 1812. So a few years later, the governor of Massachusetts, who's also a future vice president, his name was Elbridge Gerry. Okay, and so he makes an approval of what those districts are going to look like in Massachusetts, and that benefited the particular Democrat or Republican Party at the time, different party than we have today. And so then there was a Federalist newspaper, because political parties used to run the newspapers, basically said, my goodness, Jerry drew a map that makes it look like a salamander. That's a weird looking shape of a district. And so now they combine those words, gerrymander.
Salamander.
That is-
Jerry and salamander.
I know. Yeah, I
Cool.
got that. Yeah, you didn't. Yeah, I got that.
I'm just helping you because you didn't pick up on stuff before. So
That one was pretty
So-
clear.
just wanted to make sure this one didn't go over your.
Yeah, no. Mike said it, so I got it.
Yeah.
Yeah.
So this is less. This has less to do. This case has less to do with the APA than the census case, right? But it still is even another time in which the APA is involved. I mean, they're carving out a type of question that they're not going to go to, because what they're basically saying is we don't have a standard to apply, and in those instances when we don't, it's a purely political question. What you're asking us to do is to come up with a rule that says when is partisanship, which is allowed in drawing districts, when is it too partisan? And the court is like, we don't get into politics. We're not the elected branch.
And so just quickly to just kind of reinforce what we're talking about here with gerrymandering, I'm sure everybody knows, but just in case, I mean, we're talking about the process of drawing the boundaries of an elected official or of a district where people are going to vote
Sure.
to benefit a preconceived outcome of an election.
Right. So the theory of a preconceived outcome. Yeah, so a political party that's in power has the ability, after there's a census, every 10 years they can redraw the boundaries. And the party that's in power has the ability to draw those lines because they are controlling. And they can do that in a way that's purely political, that preserves their power. And they can do it in whatever way they want, as long as it's not based upon race or they're not depriving people of one person, one vote. Those are only the two things right now under the law that they have to watch out for. Otherwise, they can say,
you can draw that district however you want.
We're going to draw this district so all of the Democrats are here, and we're going to draw this one so that all the Republicans are over here, and that'll guarantee those two districts.
One seat for each.
Right.
So tie this back to land, wildlife, water.
So it gets back to the beginning of the conversation where we talked about how the census does account for how many people there are, to determine where they are, to determine how many votes in Congress, how many people go to Congress. Gerrymandering determines how you're going to draw the boundaries of where everybody's going to vote. And so when you go to the ballot box to vote for someone who theoretically is going to carry forward your conservation objectives to Congress, you can have that undone on you depending on how the boundary is drawn. And that, in turn, affects the membership of Congress and how they're going to vote and what they're going to favor. And that also means the purse strings that go out and pay for all these goods and services that we expect from the federal government, like our national parks, our Fish and Wildlife Service going out and doing counts of whatever. And basically, who wants to make LWCF fully funded, that kind of stuff. So it has a lot to do with the day-to-day things that we do care about, but just in such an indirect way we don't pay attention to
your
it.
Your ultimate representation
Yeah.
can be affected by this case. And the issues we deal with are affected by who represents you. And so it's not something that you see. It's not an impact that you see in crystal clear terms, right? But it's certainly an impact out there. The one other thing that I think the census, to circle back to the census case.
Yeah.
The one other thing, and I think you touched on it, but I want to hit it back again if I'm missing it. It really reinforced the idea of agency deference to decision making. There had been some speculation that under the current makeup of the court, the new makeup of the court, that what we've called the Chevron deference doctrine was vulnerable, right?
Which is the agency's right.
That we defer to the expertise of the agency
We're
so
going to
long
give
as
them
they
the
take
benefit of the doubt.
that they're transparent and take into account, basically they're transparent and explain their decision, that we defer to them as the experts.
Yeah.
Right?
Yeah. You can make a dumb decision as long as you explain it.
Right. This case.
So people thought that this Supreme Court might undo that, and that wasn't the case.
And what's fascinating is that you're absolutely right, Dave. There was those kinds of things that were potentially at play because it was an APA type case, and they reinforce a lot of the deference that's given. This may be an aberration because it is so odd that they actually had evidence that there was this ulterior motive. And in fact, after the case went up to the Supreme Court, within this last year, they discovered information on someone's computer that basically made it seem like, we're going to do this so we can cut out the minority vote.
Ooh, that's pretty bad.
Yes. And so there was a big speculation
Wow.
of what is the Supreme Court going to do with this? Are they going to remand it back and do all this kinds of... There was all kinds of stuff that was going on that has been discovered after the fact. So it was one of those where circumstances could have overtaken this decision, but they ruled in a way that basically said, look, what you didn't explain the reason, your real reason, and we're going to send it back for you to figure it out. So they can rewrite, they can put the citizenship question on the 2020 census. We may see it on there because they didn't do it in a way that said you can never do it. They just said you need to go back and explain yourself better.
It's that's fascinating. I appreciate the fact that you were willing to dive into this and dive into it in a way where you could say, here's how we tie this back to natural resources.
Yeah.
When you first proposed this as a topic, I'm sitting there thinking, how in the world does this tie back into what we talk about on a day-to-day basis?
Yeah.
And it's nuanced, but it's something to be aware of, and especially if you're wonky like we are. And I think what we've proven today is you might be the wonkiest of us all, Mike.
Yeah.
But
we're the one with the conspiracy theory strings and the tying things together, right?
Sure. Maybe that's even better. But that makes it even greater. You're wonkier and more skeptical.
Yeah, right.
So, I appreciate you doing that.
Nephi, did I put you to sleep?
No, my level of personal anxiety, just wondering what's going on in your brain.
Yeah.
It's just like, I'm not going to sleep for weeks.
Well, the good thing you didn't know what I was really thinking.
This is the stuff he thinks about.
I know.
Like he lies awake at night thinking about this.
Oh no, I sleep like a baby.
Because you read this all day long?
No, because I went fishing and shooting this weekend.
You know what?
That's true. That's true. Well, yeah. So again, this is just an example of how decisions that are seem to be completely outside the realm of natural resource matters that we talk about can actually come back and, over the long term, have what could be significant impacts, or it may turn out to have very minor impacts.
Yeah, it could be nothing at all. And I raise it only because, hey, this is likely in litigation going to be the next thing for at least a decade or so.
And I will say, kind of my parting thought is, for those of you who are at home that think that this stuff is like weird and wonky, you don't need to worry about it, you're wrong. You actually did, because the reality is, and I think all of us who have worked in, a high level in jobs in government knows that there's actually a lot of things going on at these levels that a few people are involved in that affect you more than you probably would like to believe. And so Mike is a conspiracy theorist, but that doesn't mean he's not right.
You always have, and you always have to look at these, especially these U.S. Supreme Court cases, for how can they be applied in other areas. Sometimes they very, very narrowly apply the law to very individual circumstances, but sometimes they can be game changers.
Yeah.
They can shift the direction of how you apply major federal laws across agencies.
Absolutely, and sometimes they're a slow burner.
Yep. And
you never know.
Yep. So let that soak in for the next week while we come up with a new way to entertain you next time on the Your Mountain podcast. And as always, until then, remember that life is about experiences, so go have one.